This is one of those courtroom moments where everything hangs in the balance. A defendant facing multiple serious charges, including resisting police and indecent exposure, now has to make a critical legal decision that could shape his entire future. But here's where it gets intense. The court is offering a deal, one that could reduce his charges significantly. The catch? He has to give up his right to a preliminary hearing. Now, think about that for a second. Would you risk going to trial and potentially facing harsher penalties, or take the deal and hope for a better outcome later? Stay with us, because this decision is about to get very real.
Good morning, Mr. Brandt.
You mind taking these off so I can sign?
You mind taking these off so I can sign?
Please, thank you. They're hot.
Please,
Keeps my manners.
I understand. Yes, I've known Mr. Brandt for a long time, and I think we'll be fine. But he does need the use of his hands.
This is hot. Thank you.
Yes,
Thank
Thank
you.
you, Your Honor.
Thank you, Deputy.
Thank you. Thank you, Mr. Bank. Come in.
Thank you, Deputy.
Are you Jack William Brandt Jr.?
The second, this is hot.
The second, Your
The
Honor.
second. And we've met. I'm Judge Middleton. We've got the assistance of two ASL interpreters to help us today.
First came the hard because I wanted to have a 100% effective communication.
I appreciate that, Your Honor. I want to have 100% effective communication.
You met Lindsey Brown back in the lockup. Also assisting us is Erica Allen. And you have worked with her before. Both interpreters have been sworn in to assist. You and I have been trying to communicate as best we can using the closed caption.
Yeah, that was a little tricky because the closed caption is not always 100% effective because the word can be mistyped or whatever. So that's why people have two live interpreter, and I really appreciate that. You're harder.
Well, you're exactly correct.
Thank you.
All right, you're here with your lawyer, Mr. Paul Gibson. You have two felony cases. The first one is file 26152FY. That alleges 2 counts of resisting and obstructing a police officer. Those are felonies, punishable by up to 2 years imprisonment. And a fine of up to $2,000. And you're alleged to be a 4th habitual offender, which would make those punishable by up to 15 years imprisonment. In that case, you are also charged with domestic assault 2nd degree, 2nd offense, which is a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. You were released on bond in that case, and you got arrested on a new case, which is 26224FY. In that case, it is alleged that you made an indecent exposure of your person. And that is all,
Yeah, that was,
that's the charge. It's not proven at this point.
okay, okay.
That is a high court misdemeanor punishable by up to 2 years imprisonment, as also a fourth habitual offender. Chief Assistant Prosecuting Attorney Joshua Robert is here on behalf of the people. He has been discussing this case with your lawyer, Mr. Gibson. If I understand the plea offer correctly, the prosecutor has agreed to dismiss the 2 counts of resisting and obstructing a police officer and the count of domestic violence, second offense. If you plead to domestic violence, first offense, which is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. And if I understand it, that plea would be taken in circuit court. The other charge is more problematic. The prosecutor has offered to dismiss the habitual offender portion of the indecent exposure charge if you plead to aggravated indecent exposure in circuit court. In order for that to happen, these matters would have to be bound over to the circuit court. That means the case is transferred to the circuit court for their jurisdiction. This court only has jurisdiction over matters that are punishable by a year in jail or less. And that is a 2-year misdemeanor. In order for the matter to be bound over, we either have to have a preliminary examination where testimony would be taken under oath to establish probable cause that you committed these offenses. If you waive the preliminary examination in these matters, the entire set of cases would be bound over to circuit court for potential entry of these pleas. But you don't have to plead to anything because you're presumed to be innocent. If you wish to have a preliminary examination in these matters, that could be set for probably next Tuesday afternoon. So the question here this morning, Mr. Brandt, is do you wish to waive these preliminary examinations and have the matter bound over to circuit court? Or do you wish to have testimony presented regarding these offenses in a preliminary examination hearing?
Let me discuss with my lawyer real quick.
I'm gonna discuss it with
Just
my
want to
lawyer
read.
real quick.
Oh, yeah.
I was going to say that.
Can I add something as they're discussing?
Just a moment. Just a
What-
minute, just a minute. Mr. O'Bear wanted to add one more thing.
Mr. Gibson raised some concerns regarding the effect of the indecent exposure conviction for his client. If he waives this case to circuit court, it leaves the option to further negotiate on these files open. And if he were to get out on bond and show us that he can not get in further trouble, that could have an effect on the plea offer. But if he has a preliminary exam, in particular on that file, there would be no further negotiations on that case.
Mr. Brandt, that's pretty common. If you waive these preliminary examinations, it would leave open the opportunity to continue to negotiate the case to try to resolve it. But if you have a preliminary examination and you are bound over, the prosecutor would revoke any plea offer. In fact, that's how I used to do it when I was prosecutor many years ago. So if you wish to discuss waiving these with your lawyer further, we can either have you go back into lockup or you can try to discuss it right here.
Your Honor, you indicated that on the first case, he's posted bond. Is that bond still in effect or has that been canceled?
It has not been canceled.
And then what is his bond in this new case, the second case?
$5,000 cash or surety.
Okay.
Laura, could you print me 2 bindovers in both of Mr. Brandt's cases? I didn't have the presence of mind to do that.
And hopefully get that changed, but if you don't waive, then you will no longer make any plea offer on that case other than the plea. So if your hope is to get them to voluntarily change the waive, so you can keep negotiating, but that's your decision.
Too much weight and stuff like that.
Issue separate from the other issues. So regardless of what happens, you still have a bond that you could post a $5,000 cashier bond to be released.
For some reason, the printed signature line on the other page. Just saying, I just want to get out of control.
If someone posts your bond. If he waives, would you agree to not seek a bond revocation hearing on the first case? Because I don't think you guys filed a motion on that.
Yeah.
Okay. They could file a motion to cancel the bond. Prosecutor has indicated if you waive, they will not seek to cancel.
So had him waive. Still be in sex offender. That's the concern.
That's still undetermined. Mr. Brandt is indicating that he's willing to waive. I have the waiver forms here.
All right, let me go through these with Mr. Brandt. Mr. Brandt, you and I had a discussion the last time we talked. I have known you for a long time. And you said people all your life think that you're dumb. And I told you that I did not think that. The fact that it's difficult for you to communicate doesn't mean you aren't intelligent. You have always been appropriate and respectful to me in my court. And I don't think that you're dumb. I think you know how to make decisions.
Thank you, Your Honor.
Sometimes you make some bad decisions. But my understanding is your decision at this point is to waive the preliminary examination in both of these cases. Is that correct?
Yes, for the indecent exposure and for the R&O.
Yes. Let me read that language to you. Mr. Gibson has got both waivers and he'll have you sign them. It says, I, Jack William Brandt II, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. And here's the important language. I voluntarily waive my right to a preliminary examination and understand that it will be bound over to the circuit court on the charges in the complaint and warrant. In each case, is that what you wish to do? All right, go ahead and sign those two bindovers. Emmett, would you take those over to Mr. O'Bear? In addition, Jack, the prosecutor has agreed not to pursue the bond violation for you getting arrested on the second charge while you're on bond on the first charge. So if you could post the bond in the second case, get out, stay out of trouble, it would help your cause.
Yes, I will, Your Honor.
Peace. I'm not peace out.
And I'm not saying peace
So
out.
I'm sorry, so Erica got it off. I've always been a peaceful man. I mean, shoot, I have
I've always been a peaceful
too
man, Your
much
Honor.
frustration,
It's just
hardship in my
frustrations and
hometown.
hardships
Because
in my hometown.
I
Because
had a lot of good friends, but they all left and left me, shunned me, abandoned me because I'm deaf. But I'm just very sick and tired of being oral all the time. Because I noticed it, my sign skill is dwindling because I don't have any different community to socialize with. That's why after I'm a good, heartful person. I learned that from my grandfather, Seth Ryan Grant, singer. He's the one who taught me how to hunt, clean, fish, and everything. Taught me how to be a world-class gentleman. And I want to get out of here for my mental health sake. On February 10th, 2026, I know I broke my bond, but I was.
All right, don't say any more about it.
Sorry, my bad.
All right, you're free to go. This matter's completed.
Alright, thank you, Your Honor.
And hopefully you can post your bond and Judge Stutzman will handle the case from here out. Good luck to you, sir.
And I'll promise to stay out of trouble.
and I promise to stay out of trouble.
That would make me happy.
Yeah, have a nice day. Yeah, have a nice day in your heart. It's good to see you again. I'm sorry, I know I keep making a lot of time not to be here, but
We'll be all right. You're good to go.
yeah. Andy always. Oh, shoot, my bad.
All right, Mr. O'Bear, I'll
Yeah.
get those bindovers from you.
What we just witnessed is a classic example of how critical decision-making plays out inside a courtroom. The defendant, facing multiple charges including felonies, chose to waive his preliminary examination. Now, legally speaking, that's a big move. It means he gave up the chance to challenge the evidence early in exchange for keeping plea negotiations alive. And in many cases, that can lead to reduced charges or lighter sentencing, but it also comes with risks. If negotiations fail, the case moves forward without that early defense advantage. The judge here made sure the defendant understood his rights, the consequences, and even acknowledged his personal struggles, which added a very human layer to the situation. But now, the real question is, did he make the right call? Would you have taken the deal or fought it out in court? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.